And start. Good afternoon and welcome to Children and Family Affairs Subcommittee. Thank you all for joining us today. And we're going to begin with Representative Jernigan leading us in a prayer. And we're going to stand and please remain standing for the pledge.
Bow your heads in prayer. Dear Lord, thank you for this day. Thank you for our republic, that we have a government by the people. Lord, please give us wisdom as we go through our proceedings today. And I say this brief prayer in Jesus' name. Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Clerk, would you please call the roll?
Representatives Bricken, Farmer, Gant, Garrett, Harris, Jernigan, Powell, Stevens, Chair Lady Littleton.
Here.
Chair Lady, you have a quorum.
Thank you. Members, do we have any personal orders? I think we have a birthday girl in the audience, Miss Emma. Let's give Miss Emma, she works with DCS. Let's give her a hand. Happy birthday. How about that? I hope you have a good day, a good rest of the day. Does anyone else have any personal orders? Seeing none, we'll just go right to business. We have 7 bills today, and this is our final calendar. So we're going to start with number 1, House Bill 2957 by Representative Hardaway. So I guess he's not here. We're going to roll him to the hill. Next is number 2, House Bill 2647 by Chairman Reagan. Properly motioned and second. You are recognized.
Thank you, Madam Chair and Committee. The bill before you codifies into law the Ombudsman Program. The Ombudsman, housed under the TCCY, serves as a neutral mediator between child services and recipients. As the program stands, the Ombudsman can only make recommendations regarding compliance with state and federal standards. Should this bill pass, the recommendations would carry far more weight. 29 other states have codified similar programs, and DCS and private providers have offered no objections to this bill. And with that explanation, I'll close by saying this bill is a critical step forward to improving the state of the child services with the amendment. So I have an amendment to put on it, but I understand there's another amendment in the committee.
There is. Which one do you want to go with?
I'm at the committee's pleasure.
Good.
Up to and including deleting this one.
Chairman Farmer, you are recognized.
Yeah, and thank you, Chairman Reagan. And members, I have an amendment that I believe fulfills the purpose of this legislation, which is to provide transparency. And what my amendment would say, it'd rewrite the bill, and it'd say by July 1st of each year, the department shall publish on their website such agency's most recent annual inspection report completed by the department. As I understand it, these agencies like to come in and inspect facilities, even though they have no statutory right to do so. This legislation, if it passed in current form, would give them statutory right to do so, which here in Tennessee, with regards to our state-ran facilities and our subcontractor-ran state facilities, have had no issues. The issue, as I understand it, that came up, that was the precipice of this bill, was a county-ran facility in Knoxville, and this amendment, Madam Chair and members, would satisfy and help with that process of transparency and get us to where we need to be. If we do have issues with state-run facilities at some point in time down the road, I know Representative Gant, myself, and Chair Lady Littleton served on our ad hoc committee a couple summers ago when we learned a lot more about our youth development facilities across the state, and it was a pleasure to do so. But with that, members, I'd move House Amendment 17253 for adoption.
Second. And Powell, you're recognized.
Thank you. And to the sponsor of the amendment, this does not include any private facilities, right? It's just public run
Chairman
or
Farmer.
state run.
Right, and as I understand it, this will just include facilities under the purview of the Department of Children's Services.
Representative Powell.
So if it's under the purview, are the private facilities under the purview of the department, or it's just the state run public entities?
Chairman Farmer.
As I understand it, any facility that houses youth in the state of Tennessee would be under the purview of the Department of Children's Services, as well of that of certain federal agencies.
Okay, thank you.
Any other questions for Chairman Farmer? Are we ready to vote on Amendment 017253 going on to House Bill 2647? All those in favor say aye. Those opposed, no. The ayes have it. Your bill goes out to civil full.
Thank you,
Oh,
Madam
that was
Chair.
just the amendment. I'm sorry. As amended. Are we ready? Are there any questions for Chairman Reagan? Seeing none, are we ready to vote? All those in favor of House Bill 2647 as amended, say aye. Those opposed, no. The ayes have it. Now you go. to
Thank you,
civil
Madam
full.
Chair and
Thank
committee.
you. So next we have item number 3, House Bill 1258 by Representative Vital. Properly motioned and seconded. You are recognized. And which amendment do you need to go with?
Thank you, Madam Chair, Lady, Committee. Drafting code is 017175.
Okay.
Rewrites the bill.
So we've got a motion second. Okay. Okay. So we're voting on Amendment 17175 going on to House Bill 1258. All those in favor say aye. Those opposed, no. The ayes have it, and without objection, we will be rolling Amendment 15634 and 17175 together. Okay. So without objection, we're going to roll those two together. So now you are recognized on your bill as amended. Representative Vital.
Thank you, Madam Chair, Lady, and thank you for clarifying that for all of us. House Bill 1258 was brought to me by Chancellor Atherton in Hamilton County, and I appreciate the members of this committee working with me to resolve some of the questions and make sure we get the language right. House Bill 1258 clarifies existing code and simply adds that a personal representative must notify a residuary distributee that they can file an exception to a claim. It sets the time frame, which is 60 days, and process in which a personal representative can notify the distributee. With that explanation, I'm happy to answer any questions.
Are there any questions for Representative Vital? Representative Stevens, you are recognized.
Thank you, Madam Chairman. I think there might be a typo in this section C. It says that each residuary distributee of an intestate decedent of the right to a creditor's claim. I think it should say the right to accept to or file exception to a creditor's claim, but that's a technical thing. Hopefully we can fix that another way.
Okay. Any other questions for Representative Vital? Seeing none, are we ready to vote? Without objection, we will be voting on House Bill 1258 as amended, going out to civil full. All those in favor say aye. Those opposed, no.
This stage where people need either a emergency surgery or something, that no one can make the decision on behalf of these patients, and they have to have an emergency conservatorship set up. So it's a necessary step in order to provide that service for the ward that does need representation in that matter, just to make sure all I's are dotted and all T's are crossed. So Chairman Farmer, I appreciate you carrying the bill, and I can support it. So that's very good. Thank you for this bill.
Any other questions for Chairman Farmer? Seeing none, are we ready to vote? All those in favor of House Bill 2003 going out as amended, say aye. Those opposed, no. The ayes have it. You move out to civil full. Up is number 6, House Bill 2431 by Chairman Farmer.
Second.
We're not properly motioned and second, but I do see an amendment.
Yes, Madam Chair. And I'm looking at House Amendment 16171.
That's what I have too. Properly motioned and second. You want to go ahead and put that on the bill?
Yes, Madam
Okay.
Chair. Yeah,
All
members,
right,
it
so
reroutes the bill. So
all those in favor of adding Amendment 16171 to House Bill 2431, say aye.
Aye.
Those opposed, no. The ayes have it. You are recognized on House Bill 2431 as amended.
thank you, members. And what this does, if a man has executed a voluntary acknowledgement of paternity, and that's at the time that a child is born, and what this bill will say is that it is that both the mother and the father would have the same legal right to the child. And if a man, if he becomes established as a party, excuse me, if you've signed under this bill, if you've signed a voluntary acknowledgement of parentage, of course, when a child's born, you can sign a birth certificate. That gives you a presumption that you're the father. And typically in the law right now, what you have to do, you have to go to court, you have to establish paternity, and then you can file a petition to set a parenting plan if you're not married, in order to give you legal right and legal access to a child. And typically right now, the way the law is written is if that hasn't been established, and you come and try to take a baby, 3 months old, year old, from a mother, the law's going to say, no. Baby's going to stay with the mother because the mother has that presumptive legal right to the child until you've been established, till your parentage has been established, and there's a parenting plan signed by the court, signed by a judge saying when you can, when you can't, when both of y'all can visit, when the child has to be returned, who's paying child support, whole 9 yards. What this bill would do would say once you sign that voluntary acknowledgement of the parent as a parent, that you would have the same legal right as the mother would at that point in time. So with that explanation, Madam Chair, I move passage.
Representative Garrett, you're recognized.
Thank you, Madam Chairman. Chairman Farmer, thank you for bringing this piece of legislation, even though I may not have the same sentiments from your bill previously. I've got some concerns on this, and let me kind of see if I can articulate those. Members, right now, I mean, obviously, if a child is born out of wedlock, which means the parties aren't married, the mother automatically, by statute, has full custody of the child, right? I mean, that's pretty obvious. If a mother gave birth, I mean, that's pretty good proof that that mother is the child. The father, in the sense, is not. I mean, they don't have any custody rights until that's established by court order. And here is my problem, where I think we're trying to make it maybe an equal footing, but you're actually shifting it more to the father under this piece of legislation, because now, I mean, the mother obviously gives birth. That is proof that she's the mother. All the father has to do is sign a voluntary acknowledgement that he's the father, and he's got the exact same rights as the mother does. And so we're shifting that. What if there's multiple? What if there's 4 or 5 folks that sign the voluntary acknowledgement of being the father, and then we've got 4 fathers that have the same rights with no court order, no custody issue, etc. And so, not that I think this is a worthy topic to discuss. Certainly, we don't want fathers to feel like they're being slighted by the court system whatsoever. But now they would have to petition the court, establish that they are the father by a DNA test or whatnot. Again, signing a voluntary acknowledgement does none of that. They just sign their name. That's it. And we have to establish that parentage, and then the judge can make a decision based upon the best interest of the children, which by far should be the very first standard that we do first before we look at the parents in a situation when we're talking about parentage or custody, et cetera. Because with that will come, well, when do I get to see the child? When will I have child support, et cetera, as part of a court-ordered petition, so we can make sure the child is adequately taken care of. So, Chairman Farmer, while I do think the intent of this piece of legislation is very good and very near, I have some concerns that we may need some further discussions on this to kind of make sure we weed out some of those issues that I'm bringing up. But I just say that without that, I'm not sure I can support the legislation in its current form just because of those issues, Madam Chairman. So those are my comments on the piece of legislation. So.
Chairman Farmer.
And thank you for that. Those comments, Representative Garrett and I, they're warranted. You brought up a really good point with regards to the those voluntary acknowledgement of paternity. I don't know, can there be more than one signed? If there are, then we're going to have some big problems here. And also, we always want to err on caution on the side of child to make sure that child's in the place that child needs to be with a parent. As well, you brought up another good point that. Yeah, well, I just think going back to that voluntary acknowledgement of paternity has may have some issues. We had this legislation was brought to me last year. Had intended to get with members over the summer and kind of talk through that. That didn't happen. I know everybody kind of gets busy during the summer, but maybe, and I'm at the will of the committee here. I'll do whatever y'all think we need to do on this bill. It sounds like it may need some work. We may need to have some further discussion. So with that, I may move just to take this off of notice and work with this throughout the summer with the members and try to get some language to address those issues that Representative Garrett brought up. I think they're well warranted. So, yeah.
Representative Powell.
So, and if I could, I had some of the same concerns when I looked at this, and I guess, then you would have to enter the court process and have the DNA test and everything else. And my concerns were that it might be a race to see who could sign that first and then claim that they have, that they are the father when in fact they might not be. And I appreciate your efforts. I understand what you're trying to do here. I do. Just kind of a complicated issue. So I appreciate your willingness to continue to work on it because I had the same concerns.
Right.
Chairman Farmer.
And just kind of following up, I remember last year, I think it's last year, Representative Parkson had brought some bills that had tried to address some of these VAP papers. Once they're signed and you miss that period to withdraw or not, even if you find out a year later that you're not the father of this child, you're still required to pay child support forever. And I know children need taken care of, and I understand the policy behind that. It's kind of hard to argue against, but at the same time, once you sign these things, once you're in, you're in. And I don't know that everybody realizes, every potential father out there realizes what that document that they're signing is so important. So I guess some of the policy behind bringing this document into this legislation and it was that it is that can be that important of a document. But I don't think the people really know that and understand the consequences behind signing these documents. So with that said, I just want to make that comment.
Representative Jernigan.
And I don't know the process, and maybe you don't know this either, but when someone signs voluntarily, does the mother not have to say, yes, that's him? Because she can't say yes to 5. I mean, is she involved in the process of saying, he signed this, and she acknowledges, yes, that's the father? Because it seems to me she couldn't do that more than once. So I don't know the process, but maybe that's just mother forced more study. I don't know, but
I would think with 5, that would be time for the paternity test.
yeah, something's got to give. But thank you, Chairman.
Representative Garrett.
Thank you, Madam Chairman, and to maybe shed some light on that is if there's no court order and the mother consents on the voluntary acknowledgement, then that can establish some rights for the father at that time. But that's in that consensual situation if the mother also signs that form. But I don't believe that to sign the form, and correct me if I'm wrong, this may be a question for legal, that the mother has to be there when a potential father, for lack of a better word, would sign it. So, thank you, Madam Chair.
Chairman Farmer.
I have no comment. I'll just renew my request. I'll just take this off notice, members, just so we can work on it. I want to get it, whatever we do, want to get it right first time, if we can.
All right. Without objection, it's taken off notice. Right. So the next one is mine.
Members, next we have item 7. That's House Bill 2704 by Chair Lady Littleton. Madam Chair, you got a motion and a second. I see House Amendment 14357. Would you like to adopt
That's
that?
correct. Yes,
Does that rewrite the bill?
it does.
Members, I got a motion and a second. All those in favor of adopting, without objection, those in favor of adopting House Amendment 14357 to House Bill 2704, say aye. Aye. Opposed, say no. Let's have it. Now we're back on the bill as amended, and you're recognized.
Thank you,
Madam
Mr.
Chair.
Chairman. This, as amended, requires the Department of Children's Services and the county medical examiners and the chief medical examiners and facilities that perform autopsies to establish policies and procedures to prioritize the completion of final autopsies reports for fatalities of children in DCS custody, children who were the subject of an ongoing investigation by Children Protective Services within 45 days preceding the fatality, and for the children whose fatality resulted in an investigation of the safety and well-being of another child in the home. So the purpose of this is sometimes the autopsies for children are over 3 years. A lot of them are up to a year, and none of them are quick. So if there's another child in the home, and there's doubt whether it was child abuse or not, we think it's really important that the child fatalities go to the top of the list of autopsies to protect the other children, and then to decide, how you move forward with the family and the parents themselves. So that's what this bill does.
And thank you for that explanation. Members, do we have any questions for Chair Lady Littleton on our piece of legislation? Question's been called. Any objection? Seeing none. Members, we're voting to send House Bill 2704 as amended to Civil Justice Full Committee. All in favor, say aye. Aye. Opposed, say no. Ayes have it. Bill passes.
It's here. So now we're back at the top of number 1, House Bill 2957 by Representative Hardaway. You're properly motion and second. You're recognized.
Thank you, Madam Chair, and thank you, committee members, for your indulgence. I'm in your sister or brother committee doing the same work here, criminal justice. I'll be short. As some of you know, even before I decided to become, before my constituents decided that I would become a state legislator, I was active in family legislation, family law. And one of the things that we paid attention to was the best interest of the child. There was a couple of bills that I proposed way back when that spoke to the inherent right of a child to know its true parents, its biological parents. And I still stand by that. And I think my voting record will suggest that I stand by that. However, I don't believe that the best interest of the child is served when we are criminalizing the parentage disagreements that sometimes raises its ugly head. I think that our civil courts have been dealing with this in a way that's been successful for decades. And any time that you talk about inserting criminal.
Thank you, Madam Chairman. I mean, I'm reading what I'm reading. It says it deletes the Class B misdemeanor offense for parenting or parentage fraud.
Yes,
That's all it does.
that's all it does.
And so I'm not sure if you can answer. I get confused at what a Class B misdemeanor is and how many classes of misdemeanors there are out there. I have no idea. So if you can answer that.
I would rather
Representative Hardaway.
take that to your legal counsel,
Okay.
Madam Chair.
So we're going to go out of session and recognize legal.
Heather Asbell, Legal Services. I just want to clarify, you want to know what a Class B misdemeanor?
First, yes.
Okay.
And then how many classes of misdemeanors do we have?
So a Class B misdemeanor is imprisonment not more than 6 months or a fine not to exceed $500 or both. And there are 3 different classes of misdemeanors.
A, B, C, I assume?
ABC, yes, sir.
Okay.
Yeah.
And what's the C misdemeanor?
A C misdemeanor is not greater than 30 days in prison, in jail, or not a fine not to exceed $50.
Okay.
Or both.
Any more questions for legal? Seeing none, we're back in session. Representative Bricken?
Yeah, just back to sponsor. I mean, you want to take away any kind of charges if someone commits this kind of fraud. Is that the primary purpose?
Representative Hardaway?
Thank you, Madam Chair. Yes, sir. I want to eliminate any element of criminal prosecution involved here.
Okay. So it wasn't a consideration of stepping it down to a C misdemeanor or anything like that?
Representative Hardaway?
Thank you, Madam Chair. If the gentleman is telling me that that would be the only progress available to me, I
don't
would
know.
certainly
I was just
be
curious.
open to discussing it. But no, I think that the success would be eliminating any criminality to this period. I think it's a situation that belongs in civil court, the same place that we're discussing the custody of these same children. And I don't think it adds to the civility of settling any of these unfortunate family situations. I think it adds fuel to the fire, and it can last for a lifetime and burn up all the goodwill in the family very quickly.
Representative Bricken? Representative Garrett, you're recognized.
Thank you, Madam Chair. Representative Harvey, thank you for this piece of legislation, but let me, I think you somewhat answered the question responding to Representative Bricken, but I want to make sure that I'm clear. I mean, fraud is a strong word. Fraud is an intent to deceive, right? I mean, you know the facts, you know they're wrong, and you continue with it, whether you're embezzling money from a company, and you know you're not supposed to take it, that is a crime, right? So if a parent commits fraud on another parent by acting like they are the parent of this child, and they are doing that willingly, deceivingly, where they commit fraud, you want to completely eliminate that can be a crime prosecuted for that fraudulent conduct in the state of Tennessee, even though it's, in my opinion, this should be a felony. But I don't know why we would be eliminating it being a misdemeanor if you commit fraud by acting like someone else's parent. I just want to understand that from your perspective on why you believe that shouldn't be a crime.
Representative Hardaway?
Thank you, Madam Chair, and thank you for the question, sir. It can be summed up with best interests of the child. I don't think that prosecuting either parent, whether it's the mother or the father, is in the best interest of the child. I think the emotional, the psychological, the mental toll that it takes upon the child is the phrase, I believe, is the juice ain't worth the squeeze. I think there are other ways to cause the offending parent to pay the price, and those could be done in civil court. I think we've been successful in how civil court has been able to go back now and demand restitution. Those type of financial penalties, I believe, are where we should be. The things as simple as having a heated argument and getting out of your character emotionally could result in criminal charges. There's no statute of limitations. Grandma could be prosecuted for something that happened when she was 18 years old, or 15 or 16. I don't think that's in the best interest of the child, no matter how old that child is at that time.
You're recognized.
Thank you, Madam Chair. Representative Hardaway, I understand the best interest of the child argument, but this isn't the child, isn't it? I would think it'd be in the best interest of the child to not be defrauded on who their parents are. That is very important in a child's upbringing to make sure. So with that, what is your definition, or what do you understand is what is parentage fraud? What is it in your definition of what we're trying to accomplish?
You're recognized.
Thank you, Madam Chair. And parentage fraud is I believe that we share the same definition. It's intentional misleading of the parentage of a certain child, whether no matter how you do it. But for me, at the end of the day, to address your earlier statement, which you repeated, I don't think you can separate the best interests of the child with the best interests of responsible parents. I think when we're talking about parentage fraud, we're talking about quite frequently a mother that might be emotional, out of character in an argument, a father that might be emotional, out of character in an argument, saying things that aren't true, whether in that moment or later on to someone else. I don't believe that the best interest of the child involves criminal charges against a parent at any age, but certainly in an instance where that parent, the child may be an adult, the parent might be grandparents to that child's children. And yet, that parent is subject to criminal prosecution. That's wrong. That's not in the best interest of the child, not in the best interest of the grandchild or any of the other family members.
You're recognized.
Thank you. You're passionate on your position, and I completely respect that. However, I would have to disagree that the actual harm that this person made to commit parenting fraud is against the very child that we're trying to say is in their best interest. So the further that relationship takes place, the further you're harming that child if this person is fraudulently, intentionally, maliciously acting like a parent and they never were. So with that, Madam Chairman, and respectfully, Representative Hardaway, I cannot support this piece of legislation because I just think we're in a very different posture, and I do not think that eliminating the crime of fraudulently acting like a parent is in any best interest of a child in the state of Tennessee. So with that, I just will not be able to support the legislation. But thank you very much for letting me make my comments, Madam Chair.
Ma'am, respond, ma'am.
You can respond, but the question's been called, so.
Thank you, sir, and thank you, Madam Chair. To the gentleman, I certainly respect your argument, and quite often you've been effective in swaying me certain ways. But on this one, I'm solid. I think you can look at the best interests of the child, and it can coincide, it can coexist with the best interests of the parents. But from assigning priority, it's the best interest of the child. But I also think you can separate the act of parentage fraud from the effects of parentage fraud. What I'm trying to do is to address the effects of parentage fraud. My statement that every child has an inherent right to know their biological parents still stands. It was used to pass a couple of bills, as a matter of fact. But I think that when we're looking at the best interests of the child, the emotional, the mental, the psychological impact on a child in sending a mother or a father to jail.
Well, I would have a question allowed.
You're recognized.
Did this statute that you're wanting to amend, did it just go into effect last July?
You're recognized.
That's my understanding.
My other question was how many criminal cases has been occurred in Tennessee because of this statute? And obviously, if it's only went in effect since last July, probably few. But so I was just curious to know how many cases we're criminalizing because of this statute before we decide to take it off the books. So, but that's all.
Any other questions? Seeing none, are we ready to vote? Without objection, we will be voting for House Bill 2957 to move out to civil full. All those in favor say aye. Those opposed? The noes have it. Sorry. Your bill fails.
Thank you, Madam Chair. And once again, thank you, committee, for your patience. I'm headed back to your sister brother group.
So this is this is going to be our last meeting for the year. So I want to say that it's been a pleasure working with all of you guys, and I think we've done a lot of good stuff, and I think we've stood by our motto, in the best interest of the child. If we can save one child at a time, we'll try and save them all. So, Representative Gant.
Madam Chair, I want to take the opportunity to thank you for your leadership on this committee. It's always a pleasure, and out of all the committees that we have up here, I think this one does a lot of good work, and it's because of your leadership that you provide in this committee, and I think every member on this committee will concur with that. So thank you very much.
Thanks, John. Thank you. Oh, Chairman Farman.
And Madam Chair, I just want to reiterate that, what makes the process work are the subcommittees, and the subcommittees are the most important part of how things are made here. And what we want to make is good policy. So I want to thank you for making it much easier when bills come out of Children and Family, the quality bills that come to Civil Justice Full Committee. It really helps, and it's because of your leadership. So just want to reiterate what Representative Gant had there to say, and we really appreciate you. Thank you so much.
Thank you. Right. So we stand adjourned, subject to the call of the chair.